Hello and welcome to everyone present here. I am very pleased to welcome all of you today for this RSLA departmental webinar series. Thank you to each one of you for being here today with us. My name is Vijay Sharma and I have the privilege of being your moderator for this today's webinar. This webinar is our departmental webinar. It is in series. We have already conducted 4 webinars before. So now it's a fifth webinar. The topic of the webinar, today's webinar is Do Our Code Really Care for the Victims of Disaster Management? So before going into this topic, let me just give the brief about our RGU, that is Royal Global University. So basically, Royal Global University, that is RGU. RGU stands for Royal Global University. RGU stands at high with its virtue of excellence and a humble contribution to the society at large. Ranked number one private university in Assam, study done by Center for Forecasting and Research, Delhi. RGU campus is more than 27 acres of land and about 12 lakh square feet built up centrally air-conditioned air for running various courses of RGU. With experienced faculty and world-class infrastructure and facilities, RGU is one of the finest universities of the country. RGU is an educational hub in the northeastern region of India that maintain a particular commitment to exceptional undergraduate and postgraduate at the same time research institution. The faculty members work closely with students to solve major scientific, technological, and societal challenges. RG is located opposite the picture square backdrop of Tirupati Balaji Temple on National Highway 37, Guwahati, Assam. So more than 20, we have more than 27 different schools in RGU. Along with that, we have PhD program. So coming back to our RSLA, that is in short form, in full form, it is Royal School of Law and Administration. We have 5 years BLLB program, and again LLM program of 1 year, and again at the same time PhD program. So this our Royal Global University has achieved within a short span of time a very high and shining position among all the universities in India due to our contribution and hard work of our Vice Chancellor Sir. With his strong personality, hard work with a positive attitude has been able to bring our RGU in a shining position, as I've already said. He is a well-known academician across the country, eminent speaker, leader, and academic administrator, and a scholar having experienced more than 2 decades in the field of academics. He has been associated with Royal Global Institution as a founder director. He was the senior vice president of MIT Group, and sir, before joining to Royal Global University as a vice chancellor, he was he served as a vice chancellor of MIT University, Chhattisgarh. So it's a brief introduction of our vice chancellor, sir, at the same time our RGU and Royal School of Law and Administration. So before doing anything else, or before going to do our main session, let me just give you a brief introduction of our today's speaker, that is Dr. Sarkar sir. Dr. Sarkar sir is an associate professor at the Faculty of Law, Jamia, Millia, Islamia, New Delhi. Dr. Sarkar sir has the area of interest in jurisprudence, human rights, disaster management, and international refugee law. His doctoral research is in the area of disaster management and international law. Dr. Sarkar has profound interest in research, especially in the area of disaster management and law. Very recently, he has authored a book titled Disaster Management and Protection of Human Rights in India with reference to international law and practice. The forward, the forward for the book has been penned down by Honorable former CJI, Chief Justice of India, Deepak Mishra sir. Besides that, he regularly presents research paper at various seminar and conference. He has been a resource person at various webinars. He has also published book review, book chapters, and monograph. He authored several legal articles under personal column, that is Conspectus Legalis in Central Chronicle, Raipur edition. Dr. Sarkar is also a manuscript reviewer with Oxford University Press. He is the editor of NLU Law Review. Further, he is a research consultant with National Institute of Disaster Management, New Delhi. So basically, let me just start by saying that the session today concerns to the topic which is extremely prevalent nowadays, and it is definitely need to be addressed by some experts. So therefore, we have with us Dr. Sarkar sir, and since our Vice Chancellor sir, he is quite busy with some international webinar. So basically, at the same time at 5, so he may not be here. So that's why I would like to welcome everyone present here on board, and it is a privilege for me to have you all. So by saying that few lines, let me just hand over this mic to our today's speaker, Dr. Sarkar sir. And sir, please put forward of your views and your presentation. Sir, over to you.
Okay. So it's my turn now?
Yes, sir.
Okay.
It's all yours.
Thank you so much for this kind introduction, and I'm really grateful to the management of Royal Global University, Honorable Vice Chancellor Sir, and faculty colleagues for inviting me to this webinar, particularly Ritu Panda and Vijay Sharma themselves. We have been on telephonic conversation with this webinar. So a very good evening to all the audience present here. And I would be very grateful if this session inspire some of you to at least think on certain issues which has not been touched till now, or maybe which has not been made the come in the core law discourse till date. So we are going to deal with these few of these things, and as you can see from my webinar title, that do our courts care for the victims of disaster? Now, when I say so, I'm not only going to confine myself to COVID, but also beyond that, we will go back a little bit and we will see that what has the courts done till date to take care of these situations of disaster, whether it's a man-made disaster or whether it's a natural disaster. Whenever we are talking about rights, and particularly protection of rights during disaster, so we have to understand that this human rights protection is the responsibility of the state. And human rights violation because of neglect, inadequate policies, or inappropriate humanitarian response, they certain times are in a really a disadvantageous position. The human rights holders, that's the people that are there, the citizens. And what happens is that the disasters usually exacerbate these pre-existing inequalities and problems. So human rights may, if there is already a problem, inequalities in the society, that gets strained and violated in situations of disaster. And whenever we are looking at any human rights discourse, we will see that the states have triple duty, that the duty to respect, protect, and fulfill the human rights of persons. Now, when we say respect, it is that the state should not actively violate the right. Second is that it should take protective measures in when there is a violation of these rights by third parties or situations like this disaster. And the duty to fulfill is that to offer certain services and goods. And there is also one more important thing, is that the state should not discriminate. That means it should not put people in disadvantageous position because of their religion, gender, ethnic origin, etc. So when we look at the right-based approach, you can see that these are the two things, that the duty bearer is the state and the right holder is the individual or collective, means the citizens. So we have an empowerment process through which we can claim the rights from the state, and the state has a responsibility towards us through its accountability process, because without an accountability there is no point in having these rights. The rights will always be there theoretically, but practically they will not be there with us. Now, if we look at the judiciary of our country, then Indian judiciary, they have earned a worldwide praise for protecting the victims of various human rights violations. Generally, we study it under the fundamental rights chapter. And all of us know that the Article 21 has been expanded to extreme levels, right? From right to life to right to die, all kinds of things have come in under Article 21. And we are very proud of that kind of jurisprudence that has been developed by our judiciary. But what happens is that in this whole journey of this fundamental rights, somewhere that the concern for disaster management and hapless victims of disaster has not been given enough attention. And still, we today, whenever we talk about disasters, they immediately think, no matter what level you are studying law, the few things that comes into our mind is that absolute liability case of MC Mehta and the Bhopal gas tragedy, which itself is a judicial tragedy. I will explain it later on. So these are the very few cases which comes in our mind. And whenever there is a disaster, we talk about ex gratia compensation, and ex gratia compensation is about the sweet will of the state when they will give. It also depends that when is it an election year or is it not an election year. So all the times it's like a knee-jerk reaction that happens from the state, and that's how we have been dealing so long until this COVID came and everybody talking about disaster management. That's why we have to understand that why it is so important. See, this is a disaster profile of India, and this profile says this is. You can see that India, in terms of disasters, mainly these are natural disasters. We are third in terms of reported disasters, number one in terms of affected population, and second in disaster mortality. And over the years, we have always been in top five, right? I don't know whether it's a matter to be proud. So this has happened. Other than that, if we look into our history, we have Bhopal gas disaster, Odisha, Gujarat earthquake, tsunami. We have Uttarakhand floods. I am talking to people from Assam. You know how difficult it is that the floods every year comes and ravage Assam with COVID, without COVID. It is a natural phenomenon that has happened, and people just take it that, oh, these are part of our life, but maybe it is not a part of our life. Maybe some of these floods, some of the, at least the consequences could have been lessened if we would have thought it in a different way. Now let me uh, uh, there is a some annotation request. Is it that I have to approve or decline? What do I have to?
Sorry, sir.
There is an annotation request which has come. So is it that I have to approve or decline? What I have to do?
Sir, you have to decline it, sir. You have to decline it, sir.
Okay. Okay. So if we see that this judicial journey, the judicial juggernaut which has happened till date, that even certain times when the executive has miserably failed, the judiciary has gone beyond the traditional roles and have transformed into an activist role. If we look at the Supreme Court judgments in terms of environmental law, you will see a plethora of judgments where new principles have been propounded by the Supreme Court, from whether it is polluters pay, intergenerational equity, you name anything that they have come across. They have come up with new principles. They have referred to various international documents, declarations and other documents with this regard for the protection of environment, the protection of victims. Nothing of such things have been done in terms of natural disasters. I don't know anybody has ever heard about sphere standard, ISA guideline, ISC guidelines, this UN guiding principles, Pinheiro principle. These are something which has intimate relationship with disaster management, but these have never been discussed by the courts. Then our Article 21, which is already I spoke about, has no right to protection from disasters or right to speedy and effective response. We haven't seen those rights emerging out of Article 21. We have also seen that certain times that Supreme Court has done legislative gap filling. We all know about the case of Vishakha, right? We all know the case of DK Basu. Vishakha came when there was no law on sexual harassment at workplace. DK Basu laid down guidelines on arrest, which is now again has come into discussion because of the custodial deaths in Tamil Nadu. These kinds of activism we haven't seen in terms of disaster. I'll tell you that even though we are today talking about the Disaster Management Act, which is of 2005, the first famine codes in India was were laid down in 1880s by the British. So if you see that the legislative journey had started from there, and then till 2005 we did not have an act. It is only some of the mega disasters like tsunami and Gujarat earthquake which forced the government to come up with this act. Even after the tsunami, for example, in Tamil Nadu, they had managed a disaster by executive orders more than a decade after the tsunami. So there is an inexplicable silence on the part of the judiciary that why they have not come up and done that kind of legislative gap filling that they have done in other areas. I will here take up some cases, both natural as well as man-made disaster, and I'll show you that how how the courts have given a stepmotherly treatment towards the victims. Now, this is first case that I can pick up is the Upar cinema tragedy case. This is a 1997 incident that happened that there was a cinema hall in Upar cinema hall in Delhi, and it caught fire, and because of that 59 people died and over 100 people were injured. Now, what happened was that the criminal trial of this case did not start even after 4.5 years of the incident. The victims have to approach the Delhi High Court, and the Delhi High Court ordered the the district court, and then it started. Finally, what happened was that they convicted the Ansar brothers, who were the owners, under 304A, which was death by negligence. When they approached the Delhi High Court for a revision petition to alter the charges from 304A to 304 Part 2, that is the culpable homicide not amounting to murder, the Delhi High Court rejected it. And not only that, when it went as an appeal to the Delhi High Court, they even reduced that punishment which was given by the lower court of 2 years to 1 year. And what is they have cited those mitigation factors as advanced age with no criminal record, and they're educated, respectable members of the society, and that's how they reduce this one. See, if these factors are taken into consideration, many white-collar crimes will never have punishment which will be for few years or even life imprisonment. Many of the criminals will have similar things to say. And one thing has to be also taken into consideration, that they became old not because of the incident, but because of the judicial delay. The day when the incident happened, they were not so old. Right? Eventually, it went to the Supreme Court. The Supreme Court division bench disagreed with that on the reduction of the sentence. Both the judges, they did not agree on that one, and they said a fine of 50 crore each would be imposed on them. It went to because there was a disagreement, it went to a 3-judge bench in 2015. They gave a judgment, and they said that the fine of 30 crore each and no prison sentence. Right? They said that whatever they have already gone during the trial, that is, they offset that prison sentence, and they said that there is no more gain in sending them to prison. So basically, they legitimize the trading off of the prison sentence with money. This particular judgment gave a kind of a impunity on the to the perpetrators in the subsequent cases, and that's why we see many times there are fire accidents, there are bridge which collapses, there are roads which collapses, people die, and nothing happens. I come to the civil case of the same Upar. What that Upar in the civil suit happened was that the High Court decision was little bit encouraging, that they at least gave compensation to the victims, and they said that the owners, the MCD, that is the Municipal Corporation of Delhi, the Electricity Board, and the licensing authority, they all have to pay a compensation to the victims. And they ordered the compensation of 2.5 crore. But here I have to mention that original petition, the compensation was for 100 crore, a punitive compensation, which they said that it should be taken as a punitive compensation to build up a trauma care center in Safdarjung Hospital in Delhi for the treatment of such accident victims. Right, then it went to the Supreme Court. The Supreme Court admitted that the last two could have performed their duties better, but they said that there is no close or direct proximity to the acts of the licensing authorities and the MCD and the fire accident and the death and the injury. And what the Supreme Court said is that these people are not to be held liable. So they exonerated those people. And in this particular case, the Supreme Court even did not follow its own principle of absolute liability that they have propounded in the MC Mehta case. What the Supreme Court did was that the Supreme Court looked into the interest of the perpetrators. They strictly adhered to the profit calculation, and they reduced the compensation from 2.5 crores to 25 lakhs. I'll tell you a little bit in this one. What they did was that this Upar people, they put some extra benches because it was the border film and it was a hit film to accommodate more people. And these extra benches were actually there previously in violation of the laws, and they counted that how much of profit they might have earned through this extra benches, the ticket sales of these extra benches. That was the kind of profit calculation they did, and they said they might have earned around 25 lakhs. So they said that 2.5 crore is way more, and 25 lakhs they ordered. They even halved the victims' compensation. They should have seized this opportunity, and they should have awarded an exemplary damages in this case, so that it could have served as a warning bell for future disasters. But they did not do so. Instead, what they did was that they created a dubious precedent before the future perpetrators. I come to another case. This is a Kumbhakonam case. This is from Tamil Nadu. This is a school fire where 94 students died. In fact, here the dead bodies that you are seeing, it is actually the Kumbhakonam victims' dead body. These are all bodies of the burnt children in Kumbhakonam. In that case, I must say that the Sessions Court was very tough on the perpetrators, and they charged the founders under section 304(2), 337, 338, that is causing grievous hurt and hurt by act endangering the life and personal safety of others, and they convicted them with life imprisonment. And they also put a fine of 51 lakh. Similarly, they had convicted the headmistress, the 4 employees of the school department, the noon meal organizer and cook. Here I must say that the source of the fire was the midday meal that was being cooked in the school premises. So they handed over them 5 years imprisonment and 3 lakh fine. Even they convicted the engineer also with 2 years of imprisonment, which certified the building to be fit. But when it went to the Madras High Court in 2017, the Madras High Court acquitted them. Here I bring to your notice a case from outside, from Russia. What happened is in 2000, there were 8 people who were killed in a mudslide. Remember this one. 2 cases that I mentioned was about man-made disaster. This one I am talking about a natural disaster. So the relatives of these victims, they said that the deaths happened due to the negligence of the state authorities who failed to give appropriate warning, and they demand compensation on negligence. So, the Russian court rejected it, and said that this is unforeseen event. So they appealed before the European Court of Human Rights. The European Court of Human Rights, they said that the state has an obligation to take appropriate steps in protecting the right to life as enshrined under the European Convention of Human Rights, similar to our constitution. Right? And they said there is a causal relationship between the administrative flaws and the death of the victims. And they said that the state had failed to take reasonable preventive measures under disaster risk reduction and the deaths caused due to the negligence of the state. So I am just trying to show you the contrast attitude of the courts. Similarly, if you look at US, there has been the role of the judiciary has been more pervasive. And here you will see there are lots of cases with regard to FEMA. FEMA is Federal Emergency Management Agency. That is their principal disaster management body in the US, which is equivalent to our National Disaster Management Authority in India, right? So there are many cases with regard where FEMA has been dragged to the court for doing or not doing certain things. Particularly this McWaters versus FEMA, it's a very famous case where the court said that providing disaster related housing assistance is a mandatory act. There, so you have to provide the victims with this mandatory housing assistance. Similarly, the last case, you can see that the Graham versus FEMA, they also said, in fact, they have a statute called Stafford Act, which is the main disaster management act. There are already certain victims assistance programs that are there, and the court said that the assistance programs are for individuals rather than the states. It's not for the states. So individuals has a claim over the assistance program that has been there enshrined in the Stafford Act. Then we come to this Bhopal gas tragedy. I don't think that any disaster management, any kinds of discussion could be completed without mentioning Bhopal. We don't go into the incident, but we all know that there was a large number of victims, and many of these victims were belonging to the economically backward communities and sections. Right here I'm not going to the caste rather than the class. They were poor people. A lot of poor people were involved, and there are lots of complexities in claiming compensation. And there was also a failed attempt to make an outside court settlement with the Union Carbide Corporation, from whose that plant from where the gas leaked. So what the government of India did was that they passed this Bhopal Gas Leak Disaster Processing of Claims Act 1985 after the disaster and gave a retrospective effect. And they said that the government of India will have an exclusive right to present the victims or enter into a compromise or withdraw proceedings in the capacity of parents petite in a mass tort claim. So they basically took up the responsibility to represent the victims in various forums, including the court. Here I must also tell you is that the government of India tried to reach out to the US courts for a judgment, but the US courts refused to entertain their claim, and they said that everything is there in India, the witnesses are there, the situation happened in the incident happened in India, so they said you better go back to your country and you proceed with your own judiciary. So the Union of India came back and they approached the District Court of Bhopal, which gave an interim relief of 350 crore rupee. And you have to also understand that at this point of time, the Supreme Court has already delivered the NC Mehta judgment. So in that backdrop, we have to understand this development. There was a civil revision petition that was filed by the UCC before the Madhya Pradesh High Court, and they upheld the liability, but they reduced the amount from 350 crore to 250 crore. Now, 350 crore as a district court during that time was a big money, that I must say. But at the same point of time, the number of victims were also huge. So eventually what happened is that both UCC and Union of India both approached the Supreme Court, and the Supreme Court directed the UCC to pay 750 crores as a full and final settlement of all claims. This settlement is going to be important in my next couple of slides. Right, so this was it may appear that 750 crore is a big money, but looking at the number of victims, it was not a big one. That it was estimated that around 6 lakhs of victims were there, present and future. So what happened was that after the Supreme Court came up with that judgment, there was an outrage, and the Union of India was forced to file a review petition. In 1992, the Supreme Court, in the review petition, they approved the settlement, and they gave this interpretation that MC Mehta is not applicable in a settlement because this is not a judgment, it's a settlement. So basically, in other way, the Supreme Court was saying that we are doing a brokerage. They also said that the settlement is not going to be vitiated either by the absence of granting hearing to the victims group, because the victims group did not go to the court because of that 1985 act. It was Union of India who represented the victims, or it lacked a reopener clause. However, what happened was that because in the review of this review petition, there was an establishment of a full-fledged hospital to treat the victims, and the Supreme Court said that the land would be given by the state government, and the capital outlay and the operational expenses will be given by the UCC. And the Union of India will provide the medical group insurance cover for the prospective victims, and the premium would be paid from the settlement amount, like from that 750 crore rupee. But what happened was that it did not stop. This was a judicial tragedy, and then the tragedy continued, that there were delay in distribution of damages, cleaning up the contamination site. In fact, it has not been cleaned even today. Discovery of documents, then ugly politics, all happened, that the healing touch came very late, or it never came in a fullest manner. Now we look at the present situation in the COVID. Now in COVID, what happened was that we have seen that there has been many PILs which were, our government was not ready, we were not ready, nobody were ready for such a massive disaster to take place, right, this pandemic. Now, of course, we were not ready. As I told you, that even the disaster management was not in the core area of legal discourse. So all these things happen. When number of PILs went to the Supreme Court in many cases junked many of these PILs. Everywhere there is a government status reports, they have unquestionably accepted these reports and have not questioned the government that whether these reports are genuine. There was a PIL seeking to direct the center to transfer wages to the accounts of the migrants in the shelter homes. The CGI himself said that if they are being provided with meals, then why do they need money for meals? It is coming from the CGI. Right? It did not even dwell over the survey report by the Hindu, which said that 96% of the migrant workers did not get ration from the government, and 90% did not receive wages during the lockdown. I'll tell you, with regard to this ration, in some of the cases, what happens is that the authorities said that where these ration cards are found. Say, for example, a person from West Bengal is working in Delhi. His ration card is from West Bengal. They said no ration to be given because you don't have a local ration card. This was subsequently modified and said if you have a ration card, you just give it to them. The misery of the migrants who were walking long distances with no food, no money, no job, without no reliable means of transport. The applications were filed before the Supreme Court to give direction to all district magistrates to take care of them so that they can go to their native places free of cost in a dignified manner. The Supreme Court said it is not possible for the court to monitor, and these are the words not of mine but of the Supreme Court. It is not possible for the court to monitor who is working and who is not working. So I am just showing you the approach of the Supreme Court in terms of another disaster. We all know the sad incident of that railway track where the workers died. 3 days before that incident, the Supreme Court disposed of a PIL seeking direction to permit migrant workers to return to their native places by trains without conditions and charges. The petitioner submitted that the precondition to obtain medical fitness certificate for travel is causing practical difficulties. The court did not entertain this one. They said no effective direction because as all necessary steps have been taken by the center state, so they disposed of the writ petition. In fact, in this whole scenario, more proactive roles have been taken by various high courts of this country, which the high courts actually acted like higher courts. So I am giving you some example. For example, the Madras High Court called it as a human tragedy. The court said one cannot control his tears after seeing the pathetic condition of these migrant laborers as shown in media. The Gujarat High Court said that the poor are afraid of dying of starvation rather than COVID. The Karnataka High Court also said that the long walk and hunger are providing fatal for the migrant. They sought information regarding this one about the special trains. So these things, why I'm talking about these things is that the concern, the humanitarian concern of the courts, which we generally expect from the Supreme Court to come, it did not come, or it came very late, bits and pieces, but it was never there, whereas the high courts did show this one. In fact, in AP High Court, this case where they said that this court notices that hundreds of migrant workers with their children and baggage are walking on the national highways. If at this stage this court does not react and pass these orders, this court would be failing in its role as a protector and alleviator of suffering. This is exactly the kind of attitude that we want from the judiciary, which was missing all through. They gave various directions, and they also said that adequate arrangement for food, drinking water, oral dehydration salts, sanitary pads, and they also asked the police to help people to walk to the nearest shelters. They talked about printing of pamphlets in Hindi and Telugu with emergency phone numbers. Wonderful. This is the kind of attitude that we want from the court. In fact, I will tell you before I go back. I will tell you there was one judgment from the Telangana High Court when the dead bodies are dying. Before they handed it over, they also said that they should be tested whether there is a COVID or no COVID. They went to the Supreme Court, and Supreme Court said that no, this kind of testing is not required. Right, so they overturned that judgment of the Telangana High Court. And I go back, means this is what I discussed some of the recent happenings there. I want to go back to some of the judgments which we can have some hope with. One of this judgment is the Gujarat High Court judgment, this Bipin Chandra Diwan versus State of Gujarat in 2002. It came just after the Gujarat earthquake of 2001. There was a PIL which was filed in front of the court that for the proper management of colossal quantity of relief material and money received as contribution, because there were a lot of reports that were there in the media of mishandling and misappropriation of this material and money. So the court intervened in this case, and they said that there is a parens patriae principle is there, and it's a welfare state. So the donors and the victims has a right to seek direction direction for the proper utilization of resources. They even went to Article 21 and said that it is the repository of all important human rights, and there is an affirmative state action to support lives of disaster victims. Right? This was a very good judgment of the Gujarat High Court. They evolved a right to assistance in calamity as an enforceable right of victims who are rendered helpless and handicapped due to natural disasters. They even went ahead and they talked about creation of a separate fund for this contribution, and they had to be managed by an authority constituted for disaster management operation. And this fund would be subject to periodic inspection and audit by the CAG nominee. I have to also mention about this one. This particular judgment came at a time before this Disaster Management Act was in existence. In fact, there was a Gujarat Disaster Management Act which came in 2003 before our National Disaster Management Act came. So the court was doing all these duty even before the act, without an act in place. They designated the chairperson of the district legal services authority as an ombudsman in respective districts to receive the complaints and grievances of quake victims. And they also directed to send a copy of this order, court order, to the National Human Rights Commission for necessary action and intervention in court proceedings. Section 12, Protection of Human Rights Act. Okay, so they did those things just for the sake of the victims. Two cases of NGT, quite a recent one, I must mention here that this was after the Uttarakhand floods of 2013. There was one case involving these hotels and developers. What the NGT said was that you have violated the conditions by the Pollution Control Board because of making kinds of alteration and kind of building in areas of no development zone. And what you have done is that by your act, you have disturbed the immediate and direct catchment of the river Ganga by changing the drainage pattern through the use of JCBs. So they said that you have to give an environmental compensation of 20 lakh rupees. And they also said that this compensation shall be used only for the restoration of the environment in that area. This was one good judgment which came. Now you see that it was a natural disaster, but in that case also the court made a private party pay for that even the natural disaster happening. Even there is another case which is this Srinagar Bandh of the Sangharsh Samiti. Srinagar is a small place in Uttarakhand, not the J&K Srinagar. That place was affected because of the hydropower. What I will just tell you what exactly happened in this case. There was a hydropower, many of these hydropower companies, and what they do is that because of their processes, lot of waste material that generates, and what they do is that they dump this waste material in the riverbed. Because of dumping of this waste material, the riverbed, the depth reduces. So taking into consideration this one, they said that this is not a natural disaster, but it's an accident within the meaning of NGT Act, because they said you have only made the situation worse by your act. So they said that you have the NGT said that you have to pay compensation for the loss of life and property, because the river bed, the depth reduced, and when there was excess water, it flowed and they flooded the area nearby and caused death and destruction. So they said that you have to pay compensation for that, and they ordered a compensation of almost 10 crore rupees and 1 lakh rupees to each applicant as a litigation cost. It's a very, very encouraging judgment, I must say, so far the disaster management jurisprudence is concerned. Finally, I must say that we have great expectation from our Supreme Court, or even the high courts, right, from our judiciary, that they have to take more a proactive, active and pro-victim stand. Right, the courts need to incorporate the international disaster management standards that are there. They have to draw inspirations from various foreign jurisprudence. There are lots of court decisions from various countries, from South Africa to US, from in Europe. They have to show the creativity. Our courts have shown a lot of creativity in various places. They have to show it in this context also. In the process, they must broaden the horizon of Article 21. So we require new rights to emerge, like as I mentioned, the right to protection from disaster, right to speedy and effective response. These things must be there. They must emphasize on accountability. See, accountability, if it is not there, there is no point in having all kinds of mechanism. They must hold the actors responsible for their actions leading to disasters. Bipin Chandra judgment, as I told you, the Supreme Court should take that one, deliver it through another judgment so that it becomes applicable in the entire country as a good precedent. I feel is that unfortunately, though, the COVID has brought disaster management in the core area of legal discourse. So I feel that this journey should continue. If this journey continue, we may have good judgments from our court protecting the rights of the victims of disaster. So thank you. I stop here, and I'm ready for questions and comments.
Okay, sir. Thank you very much for your kind deliberation, and it was a very informative. Sir has stated a very Sir has encompassed a very big horizon that is late coming of legislation in disaster matters. Apart from that, filing of the cases for victim compensation in case of loss of life, property, and at the same time claiming damages also is a very hard task to get. Even if it is get, amount is not enough. At the same time, many case laws like MC Mehta, Bhopal gas leak, and many PLs were filed and it still has been filing in the Supreme Court to get disaster relief. In fact, in the present scenario, we are having a disaster of flood in Assam, in fact in Bihar, and in fact at the same time lightning issue, thunder lightning in Bihar and Jharkhand. Many people have died there. Apart from that, a landslide in Arunachal, Assam, Bhajan, fire in the oil field. Many issues are there which are going on. So, great. Thank you very much, sir, for your kind deliberation. And now it's time to take two, three questions from our dear participants. So, basically, let me just read it out questions so sir can answer. First of all, do we need to forward our? Oh, sorry. If the Supreme Court does not take the sumo recognizes of certain matters and involved in judicial activism, then what is the alternative to this? In the light of the fact the allegation has been put on the court for favoring cases of elite classes and not for the common citizens. So basically, the question is, uh, basically it's some sort of allegation which is there in the Supreme Court. The Supreme Court always take up those cases. Like even if it is PIL file in the Supreme Court registry, always give those cases which is related with quite election matters, elite matters, and all rather than listing those cases which are related with common citizens. So, sir, what is your take on this issue, sir?
See, one of the thing which has happened in COVID is that people have relied on that High Court more than the Supreme Court. So I think now we have to activate, because the high courts are no subordinate to Supreme Court. They are also constitutional courts. So one of the issue is that let's not now, because I'm not very hopeful in the present Supreme Court that they will give very pro-victim judgments, and over a period of time, that if you see even with the pollution cases, forget about other things, even the pollution cases also, they are not they are also like favoring the companies, the rich businessmen, the automobile industry. So not many kind of pro victim kind of judgments are coming. So one is that you can try out with your high court. That is one thing. Second thing I must tell you is that we can do advocacy at our own level. Advocacy in the sense that we can write on various forums. We can even teach about those things in the class. So create an awareness. If you keep this as a sustained movement. That's what I am saying, that so much of writing, so much of advocacy, so much of webinars that has come this in the COVID time. Let these things not die down once the COVID is gone. Because as I told you, this whole disaster management discourse is not going to live and die with COVID. It will be there forever. So if you look at, for example, in the US, there are so much of activism that has gone in. In fact, Mr. Sharma was mentioning about the book. One of the chapter in my book, I have written about the US things. Right? So much of material, so much of writing, and so much of other things have gone into there. We have to have this kind of things in India also. Now you may say that, oh, even after doing that one, US is responding to this disaster badly because their president is a disaster, right? So if your political bosses is a disaster, so this kind of things you will get. The kind of things that he talks in press conferences, otherwise not even primary school students would be talking about. So we can't do anything in this regard. But these are certain things that I can tell you, is that if these kinds of things are time and again kept there, so I think that there could be some kinds of improvement in this regard. At least till now, till COVID happened, disaster management was in the shelves somewhere. The courts were not even bothered about that. Very few judgments are there. We can count them. Now at least it has come in the forefront. So now it is a time where we have to insist, by writing, by publication, by advocacy, by approaching the high courts, right? So that this disaster management jurisprudence can be further developed.
Thank you very much, sir, for your answer of that question. So basically, apart from that, we have also received some of the questions in our email prior to this webinar. Thing is that, sir, what can be the permanent solution of this mitigating of this disaster, which is very much relevant in present context? It's the flood. We have been seeing this flood as a disaster from very long. And in fact, whenever flood comes, government with their NDRF mechanism, they just vacate their place. And again, after some time, they just rehabilitate them. So
Right.
instead of doing that, why can't government, be it judiciary or executive, bring some permanent solution? Because we have been seeing it from a very long time. Again, in fact, some allegations are there at the same time. Let me just put it in a very positive way, that lots of funds comes whenever this flood affects, and from the basically from the central government to the state governments. So basically, at the regional levels, maybe it's a political issue, or it could be any issue. They reluctant to develop that type of remedies, or I should say, a defense mechanism from this flood and all. So is it a political issue, or is it some
It's a
complications are there in
political
the
issue.
implementation?
It's a political issue. See, why I'm telling you it's a political issue is that the political class is never interested in disaster management. Right? You will never see a political manifesto which has disaster management in their there. Right? So they are only interested if it is a response thing. Right? If a flood has happened, if an earthquake has happened, put some relief and response, quick relief and response, that will catch the eye. But what has happened is that even the disaster management discourse worldwide has now become disaster risk reduction. So you do things prior to that disaster. You take mitigative steps so that the disasters are not there. What happens is that, say for example, that there is something that floods are coming, so you take care of the banks, the dams that are there, the bonds that you build, all those things you take care before that. What happens is that after the flood happens, then you go on having relief camps and other things, give some goodies to the people, and to just catch their eye of common people. That's not the correct way. I can give you a specific example from Assam, because I have, as probably Sharma, you remember that I was mentioning that writing the book, I had done some research in Assam. in Dibrugarh district, I was there. So what happens is that in the village, in a particular village, it was already being flooded the year before, right? And then when I was there, the villagers know exactly where it is weak and the river will again come in. So they had made representation to the district authorities, the BDO's office. So one fine day, the district magistrate comes, makes a tour, and he goes back. Now, what happens is that ideally he should be making a fast report and send it to the state office, and from the state it should go to the central office. I followed this case in Assam, and I went to the state water department there, right? There, an engineer, right? I don't want to name him because he will get into trouble. So he told me that why every year this flood happens in Assam. So what he was telling me is that this one they have made an inspection. Now they will write a report. This inspection report will come from the district to the state office. The state office will have consultation of this one. They will do all these things, and they will eventually give this report to the Central Water Commission. The Central Water Commission will sit on that report. They will give this their own opinion. They will cross-check this one, that whether this thing has happened and what is that current scenario. By the time they approve that yes, some more work on the dams or months or whatever is required, by the time the river has changed its course. Okay, so it takes such a long time. So this is one of the things that I can tell you, that it is from Assam example I'm giving you. So this entire cycle from the village people till it goes to the Central Water Commission, and they approve the project, and the project work has to start, the river has changed its course. So maybe it will be done for over 3 years or 2 years or 5 years time. The river has changed its course. So much of things that happen. Mitigation steps, like to mitigate the disasters, we are not looking into it. We are only, even today, when the entire world is talking about, and theoretically we also know that one. Right? If we look at this one, everybody has gone to pre-disaster phase. We take some mitigating steps so that the consequences of the disaster can be reduced. And one last thing I want to tell you is that Assam has a disaster manual. Right? You please go on to ASDMA website. I think on ASDMA website this manual is available. Right? The Assam State Disaster Management Authority. This is an Assam Disaster Management Manual. If you look at that manual, I can tell you, right? No, it is better than many of the international documents. Every departments, I think there are around 30 odd departments. All these 30 odd departments work pre-disaster, during disaster, and after disaster has been enumerated. Ki kya kya karna hai. And such a detailed one, I'll give you one example. They have taken so much of care that what food to be given to the people in the relief camps, that is also written there. They are telling about giving newspaper carom board to the relief camp people. So much of nuances. You go to the on ground, nothing is happening. Nothing is happening. But on paper, please visit this Assam Disaster Management Manual. It is one of the best manual I have ever seen. Right? So this is the situation.
So actually, ground reality and in documentation there are quite differences.
And one more thing. At least two districts I can tell you: Sibsagar district and Dibrugarh district. These are the two districts where I have done some work. District Disaster Management Authority. If you look at the Disaster Management Act of 2005, there are around 29 functions that has been given to the District Disaster Management Authority. Doing everything means it is like more than Ma Durga, right? But if you look at this District Disaster Management Authority, they are only one-man army. There is only one person, and that too also he is not a permanent payroll. He is a contractual person, right? And he does not even has a personal assistant to type out reports. So he is borrowing people from other departments to do so. And disasters are essentially local. So if it cannot be top down, it is bottom up. So if your bottom level is so weak and so few people, you can't deal with disasters.
Yes, that's very true. It's a very informative that we have got such a vast knowledge from our enlightened and experienced expert on this topic. So since we are moving, and before that, I would like to request our senior faculty member, Dr. Rumi Ahmed, to give a vote of thanks to today's our speaker. Ma'am, are you there? Rumi ma'am? Maybe let me just, yes. May I request you to give the vote of thanks to our present speaker?
Hello.
Yes, ma'am, you're
Hello.
audible. Yes, ma'am.
Am I audible? Yes. Give me 2 seconds. Vijay, actually there is some technical glitch, network problem is there. So I must prefer to not to switch on my video, and only I can speak. So I won't be visible. So on behalf of Royal School of Law and Administration, I would like to thank, first of all, our Honorable Vice Chancellor, Dr. S.P. Singh, for his idea, and Professor Dr. Alok Kumar Buragohai, sir. He is chairperson academics, and the management's idea was to organize this type of academic webinar to share our knowledge from share our knowledge with different universities, with different renowned speakers and all. And I must thank for this idea to Professor Professor S.P. Singh sir, and Alok Kumar Buragohai sir, and all other members of the management to encourage us to organize this type of webinars. Hello. Hello.
Yes, ma'am, you are audible.
I'm audible?
Yeah.
Yes, ma'am.
Yeah. So I must thank Mr. Dr. Subhradipta Sarkar for his wonderful deliberation, where I found he compiled various judgments. The whole deliberation of him is full of judgments, various orders, various directions made by the High Courts and the Supreme Court, starting from his case, Upar cinema case. He also cited a judgment from the Russia court, and all these cases, national as well as international courts, and where he focused, where his main focus was disasters, whether our courts actually care for the victims of disasters, man-made as well as natural. So at last, we found that justice in all these cases, of course, justice was delayed, but of course not denied, right? I must thank Dr. Subhradipta Sarkar that he agreed with which was our proposal was started from a telephonic conversation and mail, and he agreed for such a wonderful deliberation. And I expect that he will come to our campus, Royal Global University, and I know I must congratulate that he is very familiar to the Assam, the conditions there in Assam, in Dibrugarh district and Subsagar district. He has done so much good work. He also referred that the disaster management manual in Assam, it's a wonderful international document. He compared with this document with an international one. And I must say this opinion of Mr. Subhradipta Sarkar has opened many research thought, actually research ideas to the many of the research scholars, right? We must think that why we have an international standard of document called disaster manual, disaster management manual, but actually that manual is not executed properly. So I thank you so much, Mr. Subhradipta Sarkar, for your such a wonderful deliberation, your kind effort that you have made. I must request all the students to think upon these words, how they can also play a very proactive role in the disaster management scenario in everywhere. I must thank all the students, all the faculty members from various other institutions in Assam and in all over India. I must thank thank all those technical and non-technical staffs who helped us in a very prompt manner to organize this type of webinars. Thank you so much. Thank you, Bijay. Give me this opportunity to thank